Okay, we're live.
Thank you. I'd like to call to begin the Judiciary Committee meeting for Monday, March 1st, 2021. Are there any comments from my co-chair? I don't see any. Ranking members, Fishbein or Kissel. Representative?
No, sir. Thank you.
Oh, okay. I don't see any there. So we'll move on to Roman numeral number 3 on your agenda, which are bills for review for possible JF. We have one item. It is number 1, House Bill number 6462, and that concerning use of force by a peace officer. Is there a motion?
Mr. Chair, I make a motion for a JFS. The members should be in possession of LCO number 3986, which was distributed pursuant to joint roll this morning. Again, it's a motion for JFS LCO number 3986.
The motion has been made for a JFS of LCO number 3986. Is there a second?
Second by Senator Lesser.
It has been moved by Representative Stashen and seconded by Senator Lesser. Is there discussion? So I see Representative Fishbein.
No, I get this.
Oh, sorry, Representative Stashen.
Thank you, Mr. Chair. Just with the indulgence, I'll explain the JFS language if that's
Yep.
appropriate. Mr. Chair, the bill before us is the product of and comes out of, or the underlying bill comes out of work by the Police Occupational Standards and Training Council's Use of Force Subcommittee to look at the new deadly use of force policy or legislation that was put in place by this legislature pursuant to Public Act 2001 last summer. Following this legislature meeting in special session last summer to adopt a new use of force policy, the Post Council impaneled a group of legal experts and otherwise to look at that language and to develop a uniform training standard which would be rolled out to police departments across the state. As we represented last year, at the time we passed this statute, we would work with Post in good faith to tweak where necessary certain language that would benefit and improve the training standard. The bill before you, the substitute language before you, does essentially 2 things. First, and I would argue most importantly, it extends the effective date of the new deadly use of force statute from April 1st of this year to January 1st of 2020. The reason for that is this bill is about, in the underlying bill last summer, is about improving outcomes in policing and hopefully reducing the use of deadly force throughout our state. The Post Council, as I said, met. They came out with a new training protocol last November. That protocol was officially adopted in January. Given certainly COVID restrictions and others, it's the opinion of the Post Council and I believe law enforcement that I have spoken to around the state that some additional time is needed in order to allow police departments to effectively train their officers on the new deadly use of force policy. The policy we adopted last year, again, is intended to improve outcomes, and I believe we will all benefit as a state by providing as much training as possible on the new use of force policy, and extending the effective date until January will allow police departments to do so in an orderly manner. The second thing this bill does is it makes slight language changes to the underlying use of force policy. It's my opinion, Mr. Chair, that those language changes improve the underlying bill without watering it down. As we heard testimony, Connecticut will still have one of, if not the most robust use of deadly force restrictive policies in the nation. And I think the language before us helps us meet our goal of strengthening the legal framework that governs police use of deadly force in Connecticut while staying clearly within the bounds of the Fourth Amendment. With that, Mr. Chair, I urge the committee's support for the substitute language.
Thank you, Representative Stashen, for that explanation. I just, because I caught you, and I think you didn't mean to do this, but you said January 1, 2020 is 2022, just in case someone had a question. Representative Fishbein, I know you have a comment. You're muted, Representative.
Yes, thank you, Mr. Chairman. Some questions for the proponent before I get to my comments.
Absolutely.
Thank you. Did the JFS language before us today, when did Post or the subcommittee of Post approve of what's before us here today?
Representative.
Through you, Mr. Chair, the subcommittee of Post, I believe, issued a promulgation and policy back in November, and then they met in January. As I indicated, the underlying language came to us from them, and I believe we, in the S language, we capture most of their recommended changes. Through you.
Representative Fishbein.
Thank you, Mr. Chairman. My question was, has Post or the subcommittee approved of the language, the JFS language that we're seeing for the first time today?
Representative Stashen.
Mr. Chair, through you, as I indicated, I think they have weighed in on ideas and suggestions for how to improve upon the language we adopted last year. I believe the language before us reflects that. As is often the case in drafting legislation, things go through various revisions, and this is the latest revision to that. I also would note this is not the first time, today is not the first time the good ranking member has seen this language. It was shared with him last week.
Representative Fishbein.
Thank you, Mr. Chairman. I do note with regard to that last comment, the date in section 2, hasn't that changed since the language that the good chairman just indicated I saw last week? That's a change from the language previously, correct? Through you, Mr. Chair.
Representative Stashen.
Through you, Mr. Chair, this is the language before us today is the LCO cleaned up version of the sub language. If that date was updated to be consistent with the underlying effective date, then yes, I believe there may have been a typo in the original version, which was cleaned up by LCO. But the substantive language was shared last week through you.
Representative Fishbein.
Thank you, Mr. Chairman. The language that was shared last week that was recently referenced would have the effective, the training date go into place at one point, and then the effective date, the actual utilization, would be a further date. Through you, Mr. Chair, correct?
Representative Stashen.
Through you, Mr. Chair, I'm not following the question, and I guess I would also remark that we're talking about the S language before us here.
Representative Fishbein.
Yes, I recognize that, Mr. Chairman. I just, there was a reference to the fact that I've had this language, and the language that I previously had, Mr. Chairman, had a different effect by the two different dates, and that's the subject of my question. By having two different dates in section 1 and section 2, as was in the language previously shared, the training and the implementation of the actual standard would be on different dates. Through you, Mr. Chair.
Representative Stashen.
Through you, Mr. Chair, I don't believe so. I think the intent certainly of this language is that the date, the new provisions, the use of force statute will take effect on January 1 of 2022, and the intent is that police departments will have between now and then to get up to speed on the necessary training.
Representative Fishbein?
Thank you. The language that we actually had a public hearing on had a date of October 1, 2022 in both section 1 and section 2. Who testified to us that January 1st of 2022 would be appropriate and effective for all of the peace officers that would fall within the new confines? Through you, Mr. Chair.
Representative Stashen?
Through you, Mr. Chair, I think there was certainly testimony at the public hearing that was opposed to this bill, that thought October of 2022 was kicking out the effective date too far, particularly given the desire. I think we all, or certainly the desire I have, that we strengthen the legal framework governing police use of force. I think there was also questioning of certain witnesses and proponents of this legislation as whether they needed all the way until October of 2022 or could deal with or make do with a date that was sooner than that. And it was certainly my belief that in order to hopefully satisfy both camps on that, that we would move the requested timeline up a little bit to hopefully get this in place as early as practicable, while also allowing additional time for training. Through you.
Representative Fishbein?
Thank you, Mr. Chairman. And the question was, what member of law enforcement or who actually does this, trains, all of that, testified before us that the October 1, 2022 date was insufficient for their purposes? Because I don't recall any, so I'm just trying to, maybe my recollection can be refreshed by the good chairman.
Representative Stashen?
I think I answered the question, Mr. Chairman. Like I said, I think this is the intent of this is to be hopefully a compromise between the two positions. Certainly it gives law enforcement additional time from April. And in fact, I would submit gives almost an entire year to do training from after the use of force policy was adopted last January. And that should work. I have had some informal discussions with members of law enforcement over this past weekend. And from my discussions, they believe this is a achievable date.
Representative Fishbein?
Thank you, Mr. Chairman. Can I ask with whom those informal discussions happened that they believe that this is an achievable date? Or on behalf of what entities?
Representative Stashen?
Most particularly, Mr. Chair, the chairman of the Post Council.
Representative Fishbein?
Thank you, Mr. Chairman. So Post does not train all of the peace officers that fall within the confines of this new standard, correct? Through you, Mr. Chair.
Representative Stashen?
Through you, Mr. Chair, my understanding is that Post has promulgated the training protocol, that Post will train the trainers, so to speak, and then that those trainers from each individual police department will go back and implement the training within their municipality or police unit. Through you.
Representative Fishbein?
Thank you, Mr. Chairman. I must ask, Mr. Chairman, when allegedly that training guidance was issued, because I don't believe that to be the fact. So what's the basis of that representation here to this body?
Representative Stashen?
Through you, Mr. Chair, my understanding that the Post Council issued a use of force policy adopted as of November 12th, 2020, and that document has been posted internally 2-member law enforcement units, and in fact, I believe it was shared with the leadership of this committee. Through you.
Representative Fishbein.
Thank you, Mr. Chairman. And that use of force policy has been disseminated to the departments that fall within under post-training. Through you, Mr. Speaker, or Mr. Chairman, sorry.
Representative Fishbein, Stashen.
Through you, Mr. Chair, I don't want to represent for posts that it's been disseminated. I think, like I said, it's my understanding that that document is the framework for training moving forward. Certainly if it has not been fully disseminated to member police departments around the state, is precisely why I'm here advocating that we move the effective date of the statute back out a couple months so that we can ensure that it is, and that police officers have the opportunity to fully digest and review that policy. Through you.
Representative Fishbein.
Thank you, Mr. Chairman. And the good chairman referenced legal experts that were involved in crafting or being involved with this date. What legal experts? Because I believe I did ask Chief Mello about that situation, and I know I believe he referenced an attorney, but no legal counsel. There was some college professors. What legal experts were involved in at least putting together even the original 6462 that is looking to be amended here today?
Representative Stashen.
Through you, Mr. Chair, I believe Chief Mello testified at our public hearing that the task force or subcommittee that looked at the use of force policy had both lawyers who practice in this area as well as law professors on it who looked at the policy. Through you.
Representative Fishbein.
Thank you, Mr. Chairman. So at the public hearing, we had a lot of discussion. There was a lot of testimony about Section 2C1 and the fact that it may be necessary to insert in the end of C1 between circumstances and the clause known to the officer at that time. And am I to understand that the language before us today does not include that amendment? Through you, Mr. Chairman.
Representative Stashen.
Through you, Mr. Chair, that's correct.
Representative Fishbein.
And I know there's been discussions about that, and for the record, the reason why that language is not included today, given the testimony at the public hearing that actually occurred.
Representative Stashen.
Through you, Mr. Chair, I know that the ranking member asked some questions about that language. I don't recall the committee receiving any written testimony from Post or any other law enforcement agency or others that suggested the need for an amendment to line 12 of the bill. I think there was discussion by members of this committee, but I don't recall us receiving any formal testimony or request from law enforcement to include that language. Through you.
Representative Fishbein.
Thank you, Mr. Chairman. Am I to understand that, at least in the chairman's eyes, that written testimony takes precedent over oral testimony? Is that what I'm hearing? Through you, Mr. Chair.
Representative Stashen.
No, Mr. Chair, that's not it at all. I just wanted to clarify that I know there was some testimony, there was some discussion of that issue at the public hearing. I do not recall there being a formal request from Post or others to change the language in line 12 of this bill. The requests that we received as a committee were related to other lines of the bill. Through you.
Representative Fishbein.
Thank you, Mr. Chairman. In the bill that we actually had a public hearing on, in line 16, there was exhausted was being replaced with considered, and the substitute language that we have before us today has replaced considered with the clause reasonably determined that there were no available. And that there was no public, no member of the public that brought that language to us. My question is, where did that language come from?
Representative Stashen.
Through you, Mr. Chair, that was language that was deliberated over by the chairs of this committee in consultation with certainly our legislative commissioner's office staff and others. Frankly, Mr. Chair, the reason for this change is while, at least in my mind, I could see where someone may read the word exhausted too broadly or too restrictively in line 16. The word considered seemed to be, in my mind, too permissive. It didn't account for the fact that the officer thought about something, may have thought otherwise, that it was not the best idea in the world, but did it anyways, as opposed to the language before us, which tries to strike a balance between exhausted and considered. And I do believe, I know I asked questions of Chief Mello and others during the public hearing of whether they would be accepting of some sort of compromise language between the words exhausted and considered. And I recall there being testimony that yes, in fact, that would be acceptable. So while we may not have discussed these exact words, there was extensive discussion at the public hearing about trying to find a middle ground between the words exhausted and considered. Through you.
Representative Fishbein.
Thank you, Mr. Chairman. It's an interesting position because I don't recall any written testimony being submitted suggesting this language. So, you know, I would think that the same would hold true for the language that we have sought to insert in line 12, that if I believe the position was that there was no written testimony and therefore it was rejected. I still puzzled why or where this language came from. But moving on, Mr. Chairman, the other change that the good chairman did not indicate from the 6462 language that we actually had a public hearing on to the substitute language here today is in line 33, if I believe. The removal, now post and the legal experts that we're supposed to be relying upon here had made as part of the language that we had a public hearing on, they put in the clause or dangerous instrument. And I guess foundationally, I must ask, why is that being removed in the JFS language?
Representative Stashen.
Again, through you, Mr. Chair, I believe there certainly was discussion at the public hearing that perhaps the word dangerous instrument was too broad in this context, particularly where what we're talking about here is one of several non-exhaustive factors that a jury is able to look at. And also there's the qualifying word appeared in the line before. So that something that appeared to be a dangerous instrument could be seen as enough in every instance to justify deadly use of force. And I don't think that was certainly the intent of the underlying language of the bill. I don't think that's what the Supreme Court precedence on this was, and I think was too permissive and watered the bill down too much. Certainly in the right instance, could a dangerous instrument be justification for deadly use of force? Perhaps. But it should not be, in my mind, one of the factors that would seem to more often than not justify use of deadly force.
Representative Fishman.
Thank you, Mr. Chairman. So just trying to look at the distinction, because I don't recall, once again, I don't recall any of the legal experts or any member of law enforcement submitting any written or orally testifying that this was too broad. But I guess since they're not here today and we have this JFS language, I have to ask the chairman if under the JFS language, if a individual had a chair above their head and was about to bring it down on someone else, would that be a deadly weapon under your version of this language that we have here today?
Representative Stashen.
Through you, Mr. Chair, a jury reasonably could find that, yes.
Representative Fishbein.
And thank you, Mr. Chair. And how could a jury read? I know looking at the definition of deadly weapon, I know a bludgeon appears within that definition. Are we to say that a chair in that instance, at the point that it's at, is now a bludgeon for the purposes of a deadly weapon as anticipated by the statute?
Representative Stashen.
Through you, Mr. Chair, yes, I believe it can. My understanding is that under Connecticut jurisprudence, our appellate courts have defined the term bludgeon fairly broadly. I would point the ranking member to the case of Jameson versus Commissioner Corrections as one example of that. For you.
Representative Fishbein.
Thank you, Mr. Chairman. I'm not going to go down the list of possible scenarios. I understand where we are here today, but I just wanted to ask, how about a chainsaw?
Representative sorry.
Yeah, how would that fall potentially within the deadly weapon? You know, a started chainsaw, individual is going to attack someone else, officer comes upon the scene. How would that fall within deadly weapon?
Representative Stashen.
Through you, Mr. Chair, again, it's my understanding the term deadly weapon has been interpreted fairly broadly. Also point back again that this is a non-exhaustive list of factors that the jury may look at as evidenced by the including but not limited to language in line 32 of Bill 3.
Representative Fishbein.
Thank you, Mr. Chairman. So then I must ask, sir, where does the term dangerous instrument become too much in your opinion, because law enforcement didn't testify to that?
Representative Stashen.
Through you, Mr. Chair, I think in certain instances, a butter knife or a steak knife, if someone comes charging out of a room with a butter knife or even a standard issue steak knife, and there's 6 police officers with drawn guns at that person, is the butter knife or the steak knife a dangerous instrument? Probably. Should deadly force be presumptively reasonable in that instance? I don't believe so. Through you.
Representative Fishbein.
Thank you, Mr. Chairman. The issue of section 2C1 and the inclusion of the language known to the officer at that time that the chairman's not willing to insert in there. I didn't know if the good chairman was aware that California had this same debate in 2019. Through you, Mr. Chair.
Representative Stashen.
Through you, Mr. Chair, no, I'm not familiar with the deliberations of the California General Assembly on this.
Representative Fishbein.
Thank you, Mr. Chairman. Well, Mr. Chairman, I will bring to the good chairman's attention that, well, you can easily look up the fact that there was a dispute and that ultimately that legislature resolved it by including the language that the decision by a peace officer to use force shall be evaluated from the perspective of a reasonable officer in the same situation, based on the totality of the circumstances known to or perceived by the officer at the time, rather than with the benefit of hindsight, and that the totality of the circumstances shall account for occasions when officers may be forced to make quick judgments about using force. Was the good chairman aware of that language that did finally get passed by the California legislature?
Representative Stashen.
Mr. Chairman, again, I'm not familiar with the deliberations of the California legislature on this.
Representative Fishbein.
Thank you, Mr. Chairman. I mean, I don't fault the chairman for not knowing about that, but the alleged legal experts that allegedly had a part of this, I do fault. Mr. Chairman, with regard to that section and that the need for that, I know that the clerk is in possession of an amendment. I will ask, I think this is the first time we've done this session, perhaps, and I'm just suggesting, I'm not in any way, shape, or form doing anything else, that, you know, she may have the ability to share the amendment on the screen, so that we can all be in tune and just so that.
Representative, are you calling the amendment?
Yes, sir, I am.
And I know you're asking for a second.
I don't think a second is needed, but I will ask for a second on my amendment.
Second.
Okay. And Madam Administrator, I believe, is it possible as Representative Fishbein's request suggests for that to be shared on the screen? Would you please do that? Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, this amendment merely inserts that language that we've been discussing. It's, in my opinion, and the opinion of real legal experts that I have consulted with, individuals that came before our body last week, that this language is necessary as part of this to clarify that we intend to follow the law instead of having a big old question mark. So this adds to line 5, the clause known to the officer at that time for the clarity of our officers, clarity of the public moving forward. And I ask that my fellow colleagues support the amendment. I will note it makes no other changes to the S language. I do find fault with some of the other language that's in the S language, but in the spirit of compromise and bipartisanship, I offer this amendment. So thank you, Mr. Chairman.
Thank you, Representative Fishbein. There's a motion on the table moved by Representative Fishbein, seconded by Representative O'Day. Is there further discussion?
I did, if I may, I just ask that the amendment be called by roll.
Yes, absolutely, Representative Fishbein. I had assumed that, but thank you for pointing that out. Let's see, we have Representative, I'm not sure who the iPhone is. So I'm gonna go to Representative Dubitsky.
Thank you, Mr. Chairman. Because of the way the screens are, I can't tell if I'm unmuted or if my camera.
You're visible and we can hear you.
Okay, excellent. Thank you. Mr. Chairman, I support this amendment. When an officer is in a stressful situation and walks into a situation and there's turmoil and there are people who are agitated, the officer has to make split-second decisions. And he's got to make those decisions based on what he knows. or she knows. Going back in hindsight and saying, well, the circumstances were not as the officer thought they were, therefore the officer shouldn't have taken the action that she took, is very nice as an academic exercise. But when you're talking about a split-second decision, you have to think about what position that officer was in at the time. You have to put yourselves in the shoes of that officer with that officer's knowledge, because when we all make decisions on a daily basis, we make decisions as to what to eat for breakfast. We make decisions as to what clothes to wear. We make decisions as to, everything we do. And some of those decisions have life-altering consequences. We can only make those decisions based on the information that we have, based on what we know. I'm sure we've all been in the situation where we say, well, if I knew that, I wouldn't have done whatever. Or I would have made a different decision had I known that there was a different situation, but I didn't know that. So I made the decision based on the information that I had. We have to give officers that same leeway. We have to look at the reasonableness of their decisions based on what they knew. Because that's, as humans, that's all we can do, is make decisions based on the knowledge that we have, the information that we have at the time we're making that decision. So I support this amendment. I would certainly encourage my colleagues to support it. There are serious legal consequences and to removing this language, because what we would be doing is we would be saying that every action, every decision, and all of police conduct has to be viewed after the fact, with all the knowledge that we can develop after an investigation, even if none of that information was in the possession of the officer when the officer made that split-second decision. None of us could be judged by that kind of standard. Police officers should not be judged by that kind of standard, and historically have not been. And by removing this language, we would be, I believe, the only state in the nation to hold police officers to an unrealistic and unfair standard of looking at everything in the cool light of day when they had to make this decision in the heat of the night. So I encourage my colleagues to support this amendment, and I do hope that we can have this language inserted back into the statute where it should never have been removed in the first place. Thank you, Mr. Chairman.
Thank you. Senator Champagne, I think you were an iPhone. I didn't know whose it was, so you may go now. Senator Champagne. Okay, we'll come back.
No,
Yep,
I got
there you
it. I think I muted it when it was already. All right, sorry about that, the iPhone part. It lists different things every time it comes on. So I have a question for the chair. Given the current language, can officers be held responsible for information they do not know at the time the use of force is used?
Are you putting that to me or to Rep. Stashen, who is defending the bill?
Representative Stashen.
Representative Stashen.
Thank you.
Mr. Chair, I missed the second part of the question. If you could just repeat it.
I'm sorry.
Uh,
Basically, it's simple. Under the current language that you presented, can officers be held responsible for information they do not know at the time use of force is used?
Representative Stashen.
Through you, Mr. Chair, I think generally speaking, I would say no to that. I think, but we do have to go back and look at the Graham standard. I've not had a chance to comment on the amendment. I certainly hope to, but
Not the amendment, under what is presented today by you.
well, I think we're on the amendment, sir.
Well, my hand was up before the amendment. Okay, then we can go to the amendment. The way I read this amendment basically is going to help officers, because what it's going to do is information not known to that officer at the time of the use of force should not be used against the officer. All right. If the case is we are going to use that information, then we're going to have to take time to gather more information. So if I'm a police officer, I'm across the street, and all of a sudden I hear a shooting going on at the gas station across the street. At that point, I got to start gathering information. I'm not sure if I have to call the gas station and talk to somebody inside. I have to call the building department to get a layout of the building to make sure that if there's an office behind a certain wall that nobody's in there. I have to talk to any witnesses that ran out of the building. Because if you're going to hold me responsible for information I do not know, then I'm going to have to gather that information. I'm going to have to take some time to do that. You know, putting in the fact known to the officer doesn't know everything going into a shooting, a live shooting. There's a lot of people that are going to run away. Police always run towards it. Do you want the officer running in and stopping the shooting? I mean, we can look at the school shootings in the past 20 years. We have officers at some points stayed outside waiting for backup. Another point, you have officers running in. If you want us to gather all the information, especially in a situation like that where there's kids everywhere, that's going to take some time. So, and a lot of different phone calls, because you're telling me that without that language, you're going to hold the officer responsible, you know, both civilly and criminally, for something that he didn't know going in there. Whereas I think it's the intention to get that officer in there and stop the deadly shootings, protect those people that are in those places. You know, I could give you scenario after scenario, and I may do that later in this conversation, depending on how all this goes, that I didn't know all the information, but I got in there and I stopped it. So this is an important piece here. We want the officers to act. We want them in there. We don't want them stopping. And, you know, when we talk about information not used, you gave an example of a steak knife versus a butter knife and somebody coming out of a room at 6 officers. If you heard me during the public hearing, I talked about something called the 21-foot rule. And if somebody's coming out of a room, that means you're in really close quarters, not even 21 feet. And if that person comes around the corner with a steak knife, and you're telling me that those officers shouldn't use some sort of force to stop this guy, deadly force, because he's coming at him with a steak knife. I mean, you're basically telling me, you know, let a couple of guys get stabbed and then maybe jump on them or, you know, try to use a taser or something in a stressful situation where you don't have time to draw. The 21-foot rule is you have a split second to draw your weapon, aim, and fire. Now you want these officers to use less lethal force with a guy coming around the corner with a steak knife. They have to put the weapon away, pull out a less lethal, and do the same thing. The guy's going to be on top of them. You don't have time. And, you know, there's a lot of other questions that need to be asked that the officer doesn't know. What is does the person have some sort of disability that needs to be known? We should probably call and ask that. You know, not having that language in there is going to have officers hesitating, is going to have officers looking for the information. You may talk to any professor, any legal person, even Chief Mello, who really didn't talk about the 21-foot rule. You know, I mean, everybody I talked to that day, you heard, they all failed when it came to that, and they failed because it's pretty impossible. It is pretty impossible to protect yourself. And then you also have to judge by your own language. Is it a butter knife or a steak knife that he has in his hand and he's coming at you? That he's coming at you And now you're saying, if it's a butter knife, oh, you are going to prison, officer. You know, that's how I read that. If at a minimum, you're going to be sued. And with the, you know, with what we've seen, you know, the officer can lose his house. So again, we're going to have them hesitating in a situation where they shouldn't be. This language is important. It's important because you need to get those officers in there. They need to get in there and act as soon as possible to stop the violence. There's two people, I believe, on this call today that are actual officers and have been put in life and death situations in these type of situations. And I'm pretty sure we're both going to testify for the same thing. I've had guns aimed at me. I've had to stop guys with guns. I've been hit with multiple items. And, you know, a lot of those originated from domestics. And now I've got to stop. I've got to call the victim and get more information because I basically want to have all the information going in there so it can't be used against me, not knowing it when it comes. I'm going to stop there for now. I probably will be tagging back in multiple times. Thank you.
Thank you, Senator. Representative Howard. I'm sorry, Representative Howard. I'm sorry, I skipped Representative Doucette.
No problem, Mr. Chairman. I'll wait my turn. Thank you, sir.
Thank you, Mr. Chair. Just a quick comment. I took the time over the weekend to review the Graham versus Connor decision, which I hadn't read in a while, and some of the related case law. And I guess my comment is I don't see this language anywhere in that Graham versus Connor decision. And I understand the concern, and I did have the same concern that what we're doing here is consistent with the Supreme Court jurisprudence, that we want to remain consistent with the law of the land, certainly. But again, in reviewing that decision, and I'm just looking again at the pertinent parts of that decision, I just don't see how this language is in that decision, or is, you know, I think it's just not necessary. So I guess I'm just struggling to see where this is coming from. This was not in the earlier version of this bill, I don't believe. And I understand there was a lot of testimony. Reviewing quickly the written testimony, I don't see this specific language mentioned. And again, I think Graham versus Connor speaks for itself. I think this bill and this substitute language is consistent with Graham versus Connor. So I just don't see the need for this language, and I'm struggling to understand exactly where it's coming from. That's all. Thank you, Mr. Chair.
Thank you, Representative Howard.
Thank you, Mr. Chairman. Can you see me? I'm sorry. Can you hear me?
We hear you.
Mr. Chairman, thank you, sir, for the time. I do echo what many of my colleagues said as far as the last statement. When Graham v. Connor is trained to police officers, it certainly is trained to the objective reasonableness standard from the perception of a reasonable officer under the circumstances known to him at the time. I do believe that Justice Rehnquist, when he rendered that decision, specifically said that when that objective reasonableness is determined, that it should be with the officers, the information known to the officer at the time, and not with the benefit of 2020 hindsight. He recognized when he read that decision that officers are charged with making split-second decisions. And I know that the good ranking member did reference the California law, and I think that California law, they got it right. They did it in 2019. They did it with the intent of that legislature was that peace officers use deadly force only when necessary as a last resort. And they did it. They did it well. They did it right. I don't think it comes as a surprise to anybody on this committee that there's a great divide going in our state that I think we need to work to overcome. And I think that adding this language to the Graham v. Connor standard that officers have been trained to and hold them accountable to it and make sure they're trained to it achieves our goal here of police accountability and transparency, while allowing our officers to feel that we are not setting them up to fail. And I think that the good Senator Champagne and Representative Dubinsky outlined that quite well. And as far as the idea that, you know, if we take legislation that's more restrictive on our officers here, that the Supreme Court case would prevail, I just don't know if that's the case, because there are Supreme Court cases where an officer asking for consent of a driver and getting that is not a violation of the Fourth Amendment, but clearly we've taken steps in Connecticut different than that. And I think our legislation would prevail as it's more restrictive on the officer when compared to the US Constitution. So I urge my colleagues that this is important language. I will tell you that I speak to many police officers, and many police officers feel that this is important language, and they feel that without having that language there, that again, they're being set up to fail and being attacked. And I think that we can get it right, like California got it right. I urge my colleagues to vote in favor of this amendment, and I'll be voting in favor of it. Mr. Chairman, thank you for the time.
Thank you, Representative. Representative Bimbis.
Thank you, Mr. Chairman, and thank you for the opportunity to comment on this amendment here today. And thank you to Representative Dubinsky for bringing it forward. I guess I'm going maybe attempt to oversimplify things, but I was in attendance and I heard the testimony throughout the entire day regarding the bill that's before us that this amendment tries to address. And what I also heard over and over again was a reference to Graham versus Connor. And simply said, it seems to be a standard by which most, if not all, officers should be receiving training based upon. I think based on the importance and the frequent mentioning of it, it seems to be the case that maybe we all agree on that. One of the important things to note regarding Graham versus Connor is that it is case law. Case law means this is not in Connecticut statute. This is law that was handed down, or I should say standard, handed down to us by a judge sitting on a bench, which also means that, but for this being in Connecticut statute, we can reasonably expect challenges to that standard and potential changes to that standard. Now, the legislative body is in session every year, and that's because changes happen that we attempt to catch up with and modify and correct and add to our statutes. We are making some very critical changes in a bill that passed in an emergency session over the summer that many have stated, not only at the hearing, but since the hearing in public, that changes and modifications would be entertained and made because admittedly, it's necessary for a variety of different reasons. One, most important of which is clarity. So if we're here today making changes and it's contingent on a statute that we keep referencing, or my apologies, if we keep making changes based on a standard in a case that we all keep referencing and that people came before us and testified upon, I don't see any good reason why we would not add this language to it. So when my good colleagues say I can't see the need, I hope I've highlighted at least a little bit for consideration the absolute need that if we are making changes of language based on a standard that we believe is in place now, then we should also be putting that standard in the language before us. I think that's very important. I will also remember and remind my colleagues of the testimony from Chief Mello, who said that he was comfortable because that was the standard. However, if that standard got challenged, that is a serious moment of pause. I don't think anyone in good faith, and I look to be challenged, negotiated language in this professionals or post or anybody else that was part of those meetings, by which I was not, would have indicated proposed changes to language knowing that this standard by Graham versus Connor would have in any way be challenged or not followed in the future. And essentially, not having this language, this body here today is saying that we are open to allow this language, this standard to change. Now, of course, let's play devil's advocate. And you may come back and say, well, if that standard changes, we will quickly come in and change the law in order then to catch up with it. That's great. But then let's reverse that and say, if you're changing the law now in the language, let's make it clear now that this is the standard. So I do stand by this amendment, specifically this language. As I look at the amendment, there might be some other things in the amendment that people might have differences of, but I'll also wait for the underlying bill then to make the same comments regarding the importance of this specific language. And I would have hoped that people could have agreed to have this language put in. But when we're telling our law enforcement officials, boots on the ground, people running towards harm, that this committee is not willing to adopt language that's a current standard that we're asking them to be trained on, we are asking them today, many of which who have already been trained on, thankfully. But we are asking them today to be trained on this. But we're not willing to put this language in there so that at least there's clarity. I support this amendment, and I hope my colleagues would strongly consider doing the same. If not through this amendment, take a pause and consider the language then to be added to the underlying bill in a different form, if it's offensive that an amendment is being proposed by the Republican Party. Thank you.
Senator Sampson.
Mr. Chairman, thank you. Can you guys hear and see me okay? I'm trying something new today.
I can hear you. It's hard given the way the screen is set up to see you, but you may be visible.
All right, I'll try my best. I can't tell with the amendment on the screen. Mr. Chairman, I want to first off thank my colleagues for the very good comments that they have made in support of the amendment before us. And I wasn't going to say anything because I think they did a really great job of making the case for it. But I do have a question, and the question really is something that was asked, but I don't think was properly answered, which is, without this amendment, through you, Mr. Chairman, to Representative Stashen, does this mean that an officer can actually be held responsible based on what is objectively reasonable under the circumstances being measured at a later date without what is known to the officer at the time? The thing is that the question was asked, but I don't think it was really specifically answered.
Representative Stashen.
Thank you, Mr. Chair. Mr. Chair, again, I'm not entirely sure. I'm not the proponent of this amendment, and frankly, I'm struggling with, and I've not had a chance yet to ask the proponent of the amendment, where the term known to the officer at the time comes from. From my review of the Graham versus Connor decision and its progeny, that phraseology does not appear in there. So I would submit, while the proponent of this amendment is trying to create clarity, this amendment, in fact, creates more confusion, because if anything, it would seem to somehow alter or amend what is Supreme Court precedents and law. In my mind, the cleaner way to deal with this is leave the language as is. I think we all agree here that what we're referring to is the Graham versus Connor standard. That should be clear in the legislative history and intent of this provision, and that is the way to create the clarity that all are seeking. And as I was going to say in wrapping up, that's why I would ask my colleagues to reject this amendment, because I think it creates more confusion than clarity. Through you.
Thank you, Representative Senator Sampson.
Thank you very much, Mr. Chairman, and thanks to Representative Stashen for that answer. Except, forgive me, I think the answer was all over the place. The very first answer was, I don't know. And he pointed to Representative Fishbein's amendment as an attempt to provide clarity, and that's exactly what it is. I suspect this language comes from the California law that was just spoken of. And I think that we're smart enough in our committee to make this decision to employ these few words that will put in the necessary clarity to make sure that an officer cannot be held responsible for things that are beyond his knowledge at the time an incident occurs. It's completely reasonable. I think any person on the street, if you ask them, can you hold an officer responsible for something he didn't know, they're going to say no. I don't understand the objection to trying to put this clarifying and very important language in our legislation. I'm confused by this whole issue, as a matter of fact, Mr. Chairman. We have a real issue out on the street in Connecticut. There is a crime wave occurring. And I would say that the crime wave is occurring for a number of reasons, not the least of which is some of the legislation passed by this body over the last decade that has undermined the rule of law in our state. But certainly the police accountability bill, which this is a stepchild of, has put police officers in the line of fire themselves in a way that they're concerned about whether or not they are going to be judged more critically by their actions than they should. I don't think that police officers go into that line of work because they're looking to stretch their ability to use reasonable force. I think they try and do the best job that they can. But when you're putting something in their mind that makes them wonder whether or not they should go into a building or try and save someone at a critical moment in time, we're creating a problem. This amendment is pure clarity, Mr. Chairman. That's all it is. It says that police officers should be judged by what they know at the time the incident is occurring. It's nothing more than that. I think it's unreasonable for anyone to suggest otherwise. And I really encourage the chairman, the House chairman, to reconsider his position and support the amendment. I think it's a common sense thing. It's a bipartisan thing. And I think we can get out of here a lot quicker if we could come to this agreement. Thank you, Mr. Chairman.
Thank you, Senator Sampson. And I would just say that I think that passing laws doesn't upend the rule of law. And I would just say to members that I think it has been put forward that we are ending at a time specific. So we may have to continue this at a later time, just for everyone's awareness of the clock. Representative Callahan.
Chairman, I worked in law enforcement as a peace officer, chief of probation for almost 30 years, and went through about 30 years of use of force trainings. I would offer to this committee, and as with Representative Howard and Senator Champagne, I concur with what they've said. I've been put in situations where if I second guess myself because I'm judging my reactions by what I know at that time, I'm putting myself in deadly harm. I've walked into apartments where there are children running around in diapers. There's drugs on the table. There's dogs coming out of bedrooms. There's 3 people sitting on the couch that we're trying to get control over for our safety. And people are reaching under couch cushions. People are popping out of doorways. You're making split-second decisions. And if my colleagues have to think about what may be judged later on at a later date based on their reaction to those situations, I'm afraid it could be deadly for the officers. And we don't take lightly when we go into these situations, as my good colleagues I'm sure would concur. We meet, we talk about all different scenarios that could go down when you're going into a situation, protecting children, protecting women, protecting the people that are there, and most of all, going home that night to our families. I don't want another provision that would make my officers on the street that I worked with for so many years and collaborated with for the safety of the community to have to second guess themselves and sometimes to their own demise. So I would strongly support this amendment, and I thank you for your time, Mr. Chairman.
Thank you, Representative. Representative O'Day.
Thank you very much, Mr. Chairman, and thank you for this amendment. I was on post for 10 years. I've defended state police and municipal police throughout the state, tried many police cases. And at the end of the day, I would appreciate our good chair's consideration and my friends on the other side of the aisle, this amendment. If it passes, we could be done. And to those who say it does nothing, this amendment, then what's the harm in passing it? To those who say they're not sure, well, pass it, and then we can fix it when it gets to the House. And in a show of some bipartisan support, then we can have further discussion. We do that all the time. Except I would humbly suggest that there has not been a whole lot of input from this side of the aisle on this legislation. Certainly, I had a concern with this legislation when it was brought out during the pandemic and when we couldn't have full-blown hearings. So as someone who's been on post for 10 years, who's defended police throughout the state, and has litigated in the Second Circuit Court of Appeals on excessive force cases, I would suggest that this language helps our officers and clarifies the exact statement that's been asked about concerning what standard an officer should be held to. He should not be held to any standard different than a lawyer or anybody else facing consequences for their actions. They should be held to the standard of what they knew at the time of the incident. And we want officers to act quickly. That's why qualified immunity was created by the Supreme Court. Unfortunately, Congress has sat on its hands for far too many decades concerning this and immigration and many other things. I know that based on my good chair from the Senate's comments that we may have to pass this, because I can tell you if this compromise, what we believe is a compromise, doesn't pass, we've got a lot of other amendments that and comments and questions and concerns of this legislation. But if my good friends on the other side of the aisle truly believe in bipartisan and working together, we could pass this now, vote on it, and be done, and then try and fix the legislation further going forward. And literally, we're asking for a standard that's similar to what California did. So in any event, I will hold the rest of my comments and allow others to speak, and hope and pray that my good friends on the other side of the aisle would consider this as a compromise at this point in time. Thank you very much, Mr. Chairman.
Thank you, Representative. I will just say this, and I know this is not what you meant, but I don't think disagreeing on policy necessarily implicates whether people believe in bipartisanship or not. But I do take your point. Representative Fiorello.
Thank you, Mr. Chair. Sorry, being new to all of this, I'm learning as we go, and it's quite an experience. But when I was out there talking with police officers, and this is just sort of regular rank and file police officers, and then also the public in general, like the regular folks out there who, you know, just feel a sort of an emotional desire to stand. I think it's a little bit like with teachers. Everybody who is, you're almost just like one person away from knowing a teacher, and that's why we feel such an affinity towards teachers in that profession. And we can also say that about police officers. There are that we have sort of a natural instinct to want to be understanding of how hard their job is, to always be grateful for the work that they do, and also hold them accountable. But when talking to the public, there was an understanding that we are making their jobs very hard, and that they police officers don't know what is being asked of them, and the public certainly don't want the rank and file police officers, I mean, the chiefs may have a certain perspective, but cops in general, to feel this uncertainty or lack of clarity or lack of support from the top, and use of force among all of the things that police officers do in their community, and they do so much, is a critical part. It's a small part, hopefully, because we don't want a society where there is such need for them. But these are the people who have to be ready to stand between us and violent crime. And I feel that, known to the officer at the time, with my layman, non-lawyer's brain, is as a level of clarity that really can communicate to regular officers and the public that this law is saying exactly what it's saying. You know, in these circumstances, objectively reasonable, as is known to the officer at the time. But in our conversations here on committee, Representative Stashen wondered where that language was coming from. So through you, Chairman, I wanted to see if Representative Fishbein wanted to clarify where the words known to the officer at that time comes from.
Representative, excuse me, Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, I make the representation that that actual clause does not appear in Connor. It's a interpretation and it is a compacting of the rule in Connor. What the Supreme Court said was that the reasonableness of particular use of force must be judged from the perspective of a reasonable officer on the scene, rather than with the 2020 vision of hindsight. And that's a compacting of that. We end up with the clause known to the officer at that time, because it's presumed that it's not 2020 vision in hindsight. And I will point out, Mr. Chairman, in response to the question, the California language that dealt with this specifically, that I read into the record previously, that was 71 words long. If one is looking to incorporate the 71 words, I would have no problem with that. But I'm trying to make this easier. I think 7 words is a lot easier for everyone to digest and everyone to wrap their arms around than the 71 words that California, and you know, it's the first time I've ever relied upon California for anything, quite frankly, that California adopted. So thank you, Mr. Chairman.
Thank you, Representative Fiorello.
I'll end there, but I do hope that you know, our committee will support this kind of simple but clear. Let's not even say clarifying. It's just simple language that I think, you know, is understandable to regular cops and to regular people. But thank you, Mr. Chair.
Representative Pavelak-D'Amato.
Thank you, Mr. Chairman. And I'd like to thank my colleague for bringing forward this amendment. Of course, we're talking about objectively reasonable, and that's standard and Graham v. Connor, and all those different factors that, of course, an officer has to consider, or let's say a jury has to consider whether the officer used. Now, my other colleague stated that this amendment makes it more confusing, which, you know, I don't think that is our intent, and I don't think that language actually does that. Like many of you, I also have talked to officers throughout, and one officer, I'm sure this has been discussed, you know, the 20 feet that should be between suspects or individuals, alleged suspects, and an officer. And within that time and that distance, I'm just going to read a few factors, all of these that have to go through an officer's mind in making this split decision. Some of them that I've seen articulated: the number of suspects versus the officer involved, any pre-assault indicators, action statements, size, age, and physical condition of the officer and the suspect, known or perceived physical abilities of the suspect, whether that individual may be involved in martial arts, any previous violent or mental history known to the officer at the time, is there perception of any drugs or alcohol being used, the perception of the suspect's mental or psychiatric history as well. Let's say the availability and proximity to any possible weapons. I know my colleague also mentioned someone reaching under the couch, whether something is there. Environmental factors, night, day, other physical barriers or things around in the environment. Any possible, let's say, injury to the officer in that moment, and the prolonged duration of the incident. And I know, just like with reaching under the couch, any possible indications of the suspect being armed. All of these things this officer has to see, take in, make decisions, all in a split second. And again, it comes down to not only the officer protecting him or herself, but also the other people in the room. Again, my colleague mentioned, there being kids around. Also, whether they're in public or not. Is the suspect going to flee? And then of course be a possible harm to the public or somebody else. I've also been on the other side of this with individuals that I know, and still at the end of the day, you really do have to not judge somebody who's trying to make, or wrongfully judge somebody who's trying to make the right decision at the time. Does that apply to every single officer? No. Again, you can't assume on either side that somebody is intentionally making the wrong decision. Again, this is known to the officer at the time. The officer is walking in. Now, of course, somebody else, a suspect, the officer comes in. Well, you know what the officer is there to do, right? Ask questions, see if you're doing something illegal. But the officer's walking into an unknown situation. Probably has never been into that room before. Maybe not into that particular public space in a town. And again, has to take in all of this information and then make a decision. I think this amendment does add some clarification under the guidelines of the Supreme Court case, Graham v. Connor. We debated this at length this summer. And for those of the new representatives, I hope you look back at some of that, not only the testimony written and oral testimony in committee, but also on the floor of the House when Representative Rubimbis spoke. It's a lot of information. We have to be thorough. We want to do this right. We've already, of course, passed this law. We want to, again, make it the best that it can be. And I don't see how this amendment adding "and known to the officer at the time" makes it more confusing. I'm failing to see that. Again, when we're talking about that situation where it's a quick decision and it's at the time, I think some of these standards that I've read up on and studied and taking in all the testimony and reading the case, I think this amendment does just that. So again, I want to thank my colleagues and colleague for introducing this, and I urge my my fellow representatives to support this. Thank you.
Thank you, Representative. Representative Stashen.
Thank you, Mr. Chairman. Mr. Chairman, I will just summarize by, again, encouraging, unfortunately, having to encourage my colleagues to reject this amendment. I believe this amendment is unnecessary and potentially damaging to the underlying language, and in fact could create more confusion in the mind of our hardworking officers out in the field. Clarity to the objective reasonableness standard in line 12 of this bill was not requested by Post or, to my knowledge, any of the other advocates for the police unions or the police chiefs. It certainly was not formally requested of the committee in terms of written testimony. We've heard today the proponent of this amendment himself has admitted that this language before us, this amendment before us, this language does not appear in the Connor versus Graham decision, or for that matter, any other Supreme Court precedent that I'm aware of. I think it's a given that we cannot alter Graham or the analysis of what is reasonable for an officer, but to try to distill what is 30 years of Supreme Court precedents down into 7 words, I think does a disservice. As I've said, I think the cleaner and clearer way to make the point that the ranking member is trying to make, as we have done here today, is to make it very clear in the legislative intent that we're all talking about the same thing. But Mr. Chair, what really concerns me is we've now spent an hour and a half on this, and I think this committee is well aware that the provision, the use of force provision before us goes into effect on April 1st. The main intent of the bill before us is to kick out the effective date and to allow that additional time for training. I know that the Senate is about to go into session. I really do hope that we find the time to have this debate and to get this bill through 2 chambers in the next month. But I am very concerned that by not getting this bill out of committee today, if we do not get this bill out of committee today, that the clock is going to run out on us. And I think that's unfortunate that we have, in some respects, kind of, in my mind at least, lost the forest for the trees today. Thank you, Mr. Chair.
Thank you, Representative Stashen. There's no other discussion. I would ask that the administrator would, Representative Fishbein.
Yes, Mr. Chairman, just briefly, just to address that, and certainly if the good chairman would be interested in adopting the actual language from Connor that says the reasonableness of a particular use of force must be judged with perspective of a reasonable officer on the scene rather than with 20/20 vision or hindsight, that is an actual quote. That would be appropriate, but that's not what I'm hearing. So we are looking for clarity and looking forward to protect our officers as well as the public. And I ask that my colleagues support the amendment. Thank you.
Thank you, Representative Fishbein. If there are no other comments, I'd ask that the administrator call the roll.
And just to clarify, we're calling the roll on the amendment.
Absolutely.
Okay. And just in deference of time, I will not reiterate the vote. However, if you would make sure that you do say your name before you do vote. Senator Winfield.
Senator Winfield in the negative.
Senator Winfield, oh, sorry, have it. Representative Stashen.
Representative Stashen votes no.
Senator Kissel.
Senator Kissel votes yes.
Representative Rabimbis.
Representative Rabimbis votes yes.
Senator Kasser.
Senator Kasser votes no.
I'm sorry, could you please repeat that because I couldn't see you?
Senator Kasser votes no.
Thank you, Senator Kasser. Representative Blumenthal.
Representative Blumenthal votes no.
Senator, I'm sorry, this is a wrong vote tally sheet here. Representative Fishbein.
Representative Fishbein votes in the affirmative.
Senator Anwar.
Senator Anwar votes no.
Senator Bradley,
Senator Bradley votes no.
Representative Callahan,
Representative Callahan votes yes.
Senator Champagne,
Senator Champagne votes yes.
Representative Concepcion,
Representative Concepcion votes no.
could you please repeat?
Representative Concepcion votes no.
Thank you. Representative Conley,
Rep. Conley votes no.
I'm sorry, your video didn't catch up with the audio.
Representative Conley votes no.
Thank you. Representative Curry,
Representative Curry votes no.
Representative Dillon,
Representative Dillon votes no.
Representative DeMassa,
Representative DeMassa is recorded in the negative.
Representative Doucette,
Rep. Doucette is a no.
Representative Dubitsky,
Representative Dubitsky votes yes.
Representative Fiorello,
Representative Fiorello votes yes.
Senator Flexer,
Senator Flexer votes no.
Representative Fox,
Representative Fox votes no.
Representative Godfrey,
Representative Godfrey votes no.
Representative Harding,
Representative Harding votes yes.
could you please repeat?
Representative Harding votes yes.
Thank you. Senator Haskell,
Senator Haskell votes no.
Representative Howard,
Representative Howard votes yes.
Representative Labriola,
Representative Labriola votes yes.
Senator Lesser,
Senator Lesser votes no.
could you please repeat?
Senator Lesser votes no.
Thank you. Representative Luxembourg,
Representative Luxembourg votes no.
Representative Miller,
Representative Miller votes no.
Representative O'Day,
Representative O'Day votes yes.
Representative Palm,
Representative Palm votes no.
Representative Pavlak D'Amato,
Havelock D'Amato votes yes.
Representative Porter,
Representative Porter votes no.
Representative Quinn,
Representative Quinn votes no.
Representative Rabimbus. I already got your vote, I'm sorry. Representative Riley,
Representative Riley votes no.
Senator Sampson,
Senator Sampson votes yes.
Representative Sims,
Representative Sims votes in the negative.
Representative Veach,
Representative Veach votes yes.
Representative Walker,
Representative Walker votes in the negative.
Representative Young,
Representative Young votes no.
Madam Administrator, when you're ready, if you would announce the tally.
.40 members voting, yay 14, nay 26, 0 abstentions, 0 absent, not voting.
The amendment fails, and we are going to end discussion there because the Senate is going in. We will find another time where we might continue the discussion. That discussion will happen, and the chairs and ranking members will get back to you on that. Representative Stashen, before we end, anything?
Nothing further, Mr. Chair.
Thank you. Thank you all for joining us this morning, and I hope you enjoy the rest of your day. We are, yes.
We have to vote on the bill.
There are amendments that are out there, and the discussion will continue. So that's why we're going to try to figure out if there's another time. There's no way in the time that we do not have to make that happen. And if I'm misrepresenting Representative Fishbein or Senator Kissel, please chime in.
No, sir, you are not misrepresented.
Thank you. So we will call this meeting to a close. Thank you very much for participating this morning, and we will see you at our next meeting. Thank you.
Thank you.
Adjourned.